agreeing with what Aisha has said, I think from a Nigerian perspective, we have to look at the data that is perhaps driving arbitrations away from the seat. I should say this with a caveat that the statistics I will give you flow from a legislation that no longer exists. We now have a new arbitration law, and there is a new conversation to address some of the questions, some of the issues that will perhaps come out in the course of my conversation. So I would like you to bear that in mind. Now, a good place to start in terms of what makes a competitive seat is perhaps the Queen Mary International Arbitration Survey. In the 2015 survey specifically, there are three distinct factors, all connected with the formal legal infrastructure. A modern arbitration law, which is supported by a neutral and impartial legal system, and a track record for enforcing arbitration awards and arbitration agreements. So for the arbitration law, what we then had was the Arbitration and Conciliation Act, modeled on the ancestral model law, but there were peculiarities that perhaps agitated some of the negative statistics that we see. For instance, as it concerns stay of proceedings, there was a very strange situation where Section 4 of that Act required mandatory stay unless the arbitration agreement was null void, that criteria. But Section 5 made stay discretionary and put two conditions as to when a court might stay. So firstly, there had to be no sufficient reasons as to why the case would not be referred to arbitration. And secondly, the applicant had to demonstrate that they were ready and willing to do all things necessary to progress with the arbitration. And some of the decisions we see are that, for instance, if you make an application for stay and you had not commenced the arbitration, the court might say you have not done everything necessary to show me that you are ready and willing to commence with the arbitration. Now, from a numbers perspective, what we see, and we conducted an analysis of all the arbitration-related decisions from the Nigerian courts in 2021. What we see was that there was actually a very low enforcement rate for arbitration agreements in domestic arbitration. It was 31%. In international arbitration, it was about 60%. That's still quite low. Now, that doesn't bode well when it comes to consistently upholding arbitration agreements for parties. Like I say, Section 5 of the Arbitration and Mediation Act has changed that, but we are waiting to see the case law that will develop from it. Now, from an enforcing arbitration award perspective, it was actually quite high. So domestic awards, 77% of awards will be enforced. International awards, over 80% enforced. The problem was the time to enforcement. So at the High Court, you have an average of 1 year and 9 months. Court of Appeal, just over 3 years. Supreme Court, almost 4 years. So any advantage you got from obtaining your arbitration award has been eaten away by the time to enforcement. If you go from the High Court all the way to the Supreme Court, you're looking at almost 8 years. Now, again, the conversation has changed. So under the Arbitration and Mediation Act, we have something called the Arbitration Proceedings Rules, which requires a court to list any arbitration-related application within 30 days from the date of service. So we're hoping that that will at least speed up the process. But again, we are waiting for the case law that will test these provisions. As you know, most of the cases we're seeing now emanated about 5 years ago. 5 years ago, we were still operating the Arbitration and Conciliation Act. So these are some of the dynamics that, in my view, were pushing parties away from the seats. And candidly, if we even spoke to practitioners within the country that had the best of intentions, and I see some of them in this room, they would find it difficult to have recommended that seat as an arbitral seat if they were advising clients. What we're trying to do is steer that conversation away, but perhaps that's a conversation for another day, as to whether the UAE, Dubai, Abu Dhabi, would be an alternative, a viable alternative. It very much depends. depends on a number of factors. And of course, the facilities are here. The legal infrastructure is here, as Mr. Justice Black has eminently put. But there are other factors that would determine it. For instance, up until very recently, diplomatic relations between Nigeria and the UAE were not as smooth as we would have liked it. There was a travel ban, for instance, preventing Nigerians from traveling to the UAE, which was just lifted. So if we can't come here, we can't bring arbitrations here. So there are a number of additional factors other than the formal legal infrastructure that would determine it. So the data is telling us why. We recognize why Nigeria might be viewed as a hostile seat, but the good thing is that in recognition of that, the conversation is now steering to how we might repair that.